This is not a civil rights claim. This is a copyright claim
disguised as a civil rights claim.
Viva Frei, Montreal litigator turned YouTuber, and by now I'm sure you all remember that wonderful, beautiful video of two toddlers running to see each other after daycare, hugging in the streets of Manhattan. It was a thing of beauty, no question about it. And I'm sure you all also remember that that video was turned into a political meme by one Carpe Donktum, was retweeted by Donald Trump or the Donald Trump campaign, and was taken down off of Twitter for copyright violations. And if you've been following my channel for long enough, you'll recall that I actually did a vlog on the subject when Jim Acosta referred to that meme as a fake or manipulated video, and in that vlog I actually made a rather obvious but bold prediction that Carpe Donktum's check was in the mail as relates to a copyright strike for that video. If you unironically refer to a meme that was published as a meme and intended to be viewed as a meme as a fake video, you are in fact confirming that you are fake news. Jim Acosta,
I'm looking at you.
Apparently, as of the date of shooting this vlog, while the video was removed from Donald Trump's account for a copyright claim, it was left on the original uploader's account, Carpe Donktum, without a copyright claim. Although I do suspect that check is in the mail, Carpe Donktum. The world being what it is, politics ruining everything, political prosecution of certain crimes being the norm, Carpe Donktum's Twitter account was in fact permanently suspended, if you can believe that Orwellian term,
Permanently suspended
for copyright violations as a result of that particular video. First, Carpe Donktum's Twitter account was permanently suspended for alleged copyright violations, and now he, along with Donald Trump personally and the Donald Trump campaign, is being sued in New York State court for alleged civil rights violations. And I'm telling you, this lawsuit is not a civil rights claim, it is a disguised copyright claim. Supreme Court of the State of New York, County of New York, and you have all of the parents of the children as plaintiffs against Logan Cook, aka Carpe Donktum, Donald J. Trump, and Donald J. Trump for President, Inc., jointly and severally. The lawsuit starts by introducing the plaintiffs, but bottom line, plaintiffs are the parents of the children. It gets interesting when we get into the defendants. At all times relevant to this lawsuit, Logan Cook was a resident of Overland Park, Kansas, and holds himself out as a creator and distributor of social media, quote, memes, end quote, for money, often in support of right-wing conservative causes, including but not limited to defendant Donald J. Trump and his re-election campaign, defendant Donald J. Trump for President, Inc. At all times relevant to this lawsuit, Trump is an individual who maintains his primary personal residence in Mar-a-Lago, Palm Beach, Florida, and on information and belief also maintains a residence in New York City, County of New York, in the state of New York, as well as 1600 Pennsylvania Avenue, Washington, D.C., at the White House. Although Trump was at all times relevant to this lawsuit the President of the United States, he is being sued here in his individual capacity in view of the fact that his actions involved in this case were done as a private United States citizen. Although Trump was at all times relevant to this lawsuit the President of the United States, he has never divested himself from his business interests and continues to profit from and to promote the, quote, Trump brand, end quote, and name and his private business and commercial interests. Now, I'm not sure why the question of divestment is relevant. I suspect the plaintiffs just wanted to include that in the lawsuit as some sort of political jab, but there is in fact a legal question as to whether or not a sitting president can in fact be sued. In the Paula Jones versus Bill Clinton lawsuit, the Supreme Court did in fact come to the conclusion that a sitting president could be civilly sued for acts that were unrelated to his or her presidency, but that didn't answer the question as to whether or not the president could be sued at state-level courts. To the extent that the Supreme Court specifically declined to answer that particular question, it will undoubtedly be a question that will be raised in the context of this lawsuit, but that is not where we are going with this vlog. On July 11, 2019, Cook met with Trump at the White House for a, quote, social media summit, end quote, where Cook reportedly had a private meeting with Trump in the Oval Office, wherein Trump referred to Cook as, quote, the genius, end quote. Cook, via his Instagram account entitled, quote, Carpe Donktum, end quote, describes himself as, quote, sarcastic memesmith, specializing in the creation of memes to support President Donald J. Trump, end quote. The lawsuit then goes on to describe the creation of the video at issue, which is a beautiful video of two young kids meeting each other after the first day of school, and they run down the street and hug each other. It is a thing of beauty. Everyone can agree on that. I think we can also all agree that once you put something on the internet and it goes viral and becomes part of internet culture, you are going to see variations, parodies, and remixes of that original video, to say the least. Just ask Dave after Dentist. Because the video was objectively beautiful and caught a natural moment between two children, it went viral, and because it went viral and became part of the internet culture, this happened. Approximately 1 week later, unknown to all of the above named plaintiffs at that time, Cook, without plaintiffs' written consent, manipulated and adulterated the plaintiff's video, cut it down in size, and knowingly used a portion of it out of context, sending out an extremely distorted and false message. Now, the first thing I noticed about this allegation is that the terms manipulated and adulterated seem to be in a different font than the rest of the allegation, meaning that somebody actually went back to this allegation to add or modify those particular descriptive terms. And the second thing I noticed is that you cannot refer to a meme as manipulated and adulterated. Now, this is a point I've made in previous vlogs, including my vlog on Jim Acosta relating to this particular video, where people refer to the video as a manipulated video, or the vlog where Donald Trump superimposed his head on Rocky Balboa's body, and mainstream media actually refer to that as a doctored photo. Calling memes doctored or adulterated or manipulated photos or videos is intellectually dishonest in that nobody is being led to believe that they are original. They are obviously jokes. That is why they are called memes. The purpose, the very essence of a meme is not to pass it off as authentic, but to pass it off as a political commentary. Parentheses closed. Let's get back to the lawsuit and see what the allegations are and the basis for this lawsuit. The defendant, Cook, in creating the video and sharing it with Trump and or campaign, used the pictures and likeness of plaintiffs MH and FM without plaintiff's consent for advertising purposes and or for the solicitation of patronage for himself and or for Trump and campaign in the state of New York. The defendant, Cook, added fraudulent text to the manipulated video, further distorting it, including but not limited to improperly applying the CNN chyron, referred to it as, quote, breaking news, end quote, throughout the manipulated video, and specifically created a negative and racist overtone to the video depicting MH running and being chased after by FM. The defendant, Cook, falsely and maliciously added in font, quote, terrified toddler sick, runs from racist baby, end quote, and thereafter, quote, racist baby, probably a Trump voter, end quote. Now, the way it's being described in the lawsuit, you would think that Carpe Donktum did this in order to pass off his video as an authentic, believable video and not as a total parody that no one in their right mind would take seriously. And it almost sounds like the parents are getting at a sort of defamation aspect of their claim. Cook created the false video knowing of its falsity and or with reckless disregard for the true nature of the original video.
That's the joke.
I don't know who's going to be convinced by this drafting, but it is in fact the exact opposite. Carpe Donktum created the meme specifically to contrast the original essence of the original video, not to pass it off as an original video. Cook created the video for the purposes of commercial exploitation for his economic benefit and or that of the co-defendants Donald Trump and campaign. Cook sought and or collected money from people for making memes, including but not limited to the subject video of the plaintiff's children taken by their parents. Trump and campaign sought donations and or money for the re-election campaign, including by way of using Cook's memes, including the subject video. On Thursday, June 18, 2020, the night before Juneteenth, Trump utilized his personal Twitter page @RealDonaldTrump and retweeted Cook's manipulated video of the subject young children without the plaintiff's written consent. Shortly thereafter, campaign via its Twitter page @TeamTrump retweeted Trump's post of the above-mentioned distortion of plaintiff's video without plaintiff's written consent. Trump, in publishing the new video, misappropriated the pictures and likeness of the plaintiffs MH and FM without plaintiff's consent. Trump did so to exploit the children's images for his own purposes and gain. Trump, in publishing the video, used the pictures and likeness of plaintiffs MH and FM without the plaintiff's consent for advertising purposes and or for the solicitation of patronage for himself and or campaign in the state of New York, pushing his brand of sensationalism in complete disregard for the truth. The lawsuit then goes on to allege how Twitter took down the allegedly infringing video, and the plaintiffs seem to potentially make something of an interesting admission. The next day, on Friday, June 19, 2020, Juneteenth, Facebook and Twitter removed the above-mentioned stolen video from Trump's and campaign's postings in view of the fact that it was in violation of their copyright rules, did not have the appropriate authorization by the above parents plaintiffs, as well as it was, quote, likely to cause harm, end quote, in particular to all of the above plaintiffs. The following week, on Tuesday, June 23, 2020, Twitter permanently banned Cook and Carpe Donktum in view of the multiple infractions that they had perpetrated by way of unauthorized use of various videos that were created without written consent from plaintiffs and likely to cause harm to them. Now, I am fairly certain it is this paragraph 38 of the lawsuit that caused Carpe Donktum to issue a press release via Twitter through the account of Tim Young. The relevant part of it reads as follows. Contained in this rambling and often hilariously written document is a stunning admission. The plaintiffs admit without prompting that the DMCA copyright takedown that they filed against me directly led to the permanent suspension of the Twitter account I have owned and operated since 2008. My account @Carpe Donktum, which I had built over the course of 12 years and had amassed 273,000 followers, was not only my preferred outlet for expressing my First Amendment rights, it also served as an archive of all my artistic work. In early July, I filed counterclaims to both Twitter and YouTube, officially contesting the DMCA takedown of my account. In these counterclaims, I formally challenged their legal standing to file such a claim and staunchly defended my First Amendment rights to political speech, and specifically claimed my legal right to fair use, parody, satire, and political commentary. Once these counterclaims were filed, the claimant, the parents, had a period of 10 days to provide proof that they had filed a copyright lawsuit against me or abandon their claim. claim. The plaintiffs declined to file a lawsuit or a cease and desist against me during the allotted time, effectively admitting that their claim was invalid. Because their copy claim was invalid and would not stand up in court, they instead chose to file what is essentially a copyright lawsuit pretending to be a civil rights lawsuit. Due to their admission that they filed a fraudulent DMCA takedown which directly led to my suspension, I intend to seek compensation for the loss of my now suspended Twitter account and for all the losses caused by my wrongful suspension. That value will be determined at trial but should be substantial. And before we get into the crux of this vlog, let's just go through the causes of action briefly. First cause of action, violation of New York Civil Rights Law Section 50 and 51. All defendants owed a duty to plaintiffs so as to abide by the above laws and to refrain from using videos or likeness of people without prior consent and to refrain from using the video for crass commercial exploitation and or advertising purposes and or as a solicitation for patronage in an attempt to raise or to make money. All defendants flagrantly and knowingly violated these statutes in numerous regards, but in particular in their failure to obtain written consent of the above plaintiff's parents before utilizing the video, as well as utilize this stolen video as a method by which to advertise or for purposes of crass commercial exploitation, advertising, trade, and or make money for each of them individually, themselves collectively, and or for Trump and or campaign. As a direct and proximate result of all of the defendants' violations of the above statutes, all of the plaintiffs herein have sustained damages including but not limited to A. Conscious pain and suffering, B. Mental anguish, C. Fright and shock, D. Denial of social pleasures and enjoyments, E. Embarrassment, humiliation, or mortification. The parents are also seeking a restraining order and permanent injunction as provided for by law, but let's just read that part of the conclusion. Wherefore, plaintiffs respectfully request this honorable court enter judgment in their favor and against defendants for A. Damages in a sum that exceeds the jurisdiction limits of all lower courts. B. Restraining the defendants from using plaintiffs' images, names, likeness, and voice by way of a preliminary injunction and a temporary restraining order. C. Permanent injunction barring defendants from using plaintiff's video in any way, and other damages. The second cause of action is for intentional infliction of emotional distress, the third cause of action for negligent infliction of emotional distress, and the fourth cause of action for general negligence. And as far as I am concerned, you know what the ultimate kicker of this lawsuit is that it's the parents themselves who have made this video available for licensing, marketing, and advertising. If you go to YouTube, you will see that this video is being licensed by Jukin Media, a video licensing agency, and one of the options they give is specifically for advertising. Now, Section 50 of New York Civil Rights Law reads as follows. A person, firm, or corporation that uses for advertising purposes or for the purposes of trade the name, portrait, or picture of any living person without having first obtained the written consent of such person, or if a minor of his or her parent or guardian is guilty of a misdemeanor. It is going to be one of the basic and essential questions of this lawsuit as to whether or not what Carpe Donktum, Donald Trump, and the Donald Trump campaign did with this video was use it for advertising purposes or for the purposes of trade. I am skeptical in fact and in law that applies to the use in this particular case, but let's set that aside for the moment. Let's also set aside all of the defenses in copyright law that the use being made of this particular video was clearly parody or satire, therefore fair use. Let's set that aside as well. The parents, through Jukin Media, have made this very video available for advertising purposes. So it's not one of those cases where someone takes a picture of a kid in a park and the next day it's on the front of a modeling magazine. The parent plaintiffs have willingly made this video available for advertising purposes, so it's not a civil rights violation, it is a licensing violation at best. From Jukin Media's website, how do you define, quote, advertising commercial use, end quote? Quote, commercial advertising, end quote, is defined as a use which promotes a product, brand, or service. Why do I need a license to use one of Jukin's videos? In order to download and use or post a Jukin video in a production or on a social media platform online, you need to purchase the correct license option for that use.
This ensures that our partners who have created the video are fairly compensated.
Now, I'm not saying this judgmentally. I license videos out and I have used Jukin Media in the past. All that I'm saying is that this is not a civil rights violation. This is at best a licensing violation. Maybe I am wrong. I have been wrong in the past and I'll be wrong again in the future. And I am going to ask Robert Barnes tonight during our live stream, which if you're watching this in the future is linked right here. Give it a watch. It will undoubtedly be a great one. Regardless, I will be following this story. So if there are any developments, I'll be doing a vlog on it. With any luck, maybe one day I can actually get a live stream with Carpe Donktum to discuss the entire situation. But with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, Subscribe Star, YouTube membership. We've got merch. But more important than all of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!